Peter, I'm just so fucking, you know, bogged down by stuff. I just can't get a fucking moment to think and do stuff. Um, did you read the email?
Yes, I did. I made a comment. I said, it's like a big change of attitude.
Not just that, they're so fucking, like, openly dishonest. I can't even fucking explain. So what they're saying now is that, firstly, they're happy for the contempt thing to be heard.
Yep.
I think part of this is that the registry has gone back to them and said that we can't pay the filing fee, or that's what they think. Do you know what I'm saying? Because we applied for the fee waiver first, and I don't know what the fuck they're thinking, but it's just ridiculous. But the other thing that they're saying is that their contempt application, our contempt application across the two proceedings should be listed together.
Yes.
And that because we've already filed the constitutional notice in one, and the law prevents the court from proceeding without. Do you see what I'm saying?
No, it's okay. I know they've made that comment that, you got to give time regards to...
No, what I'm saying is that previously, during the hearing, when I was saying all of that stuff, no one was fucking listening to me.
Oh, yeah, no, I get that. That's what I'm saying. Big change in their attitude as to how they're, what they're saying. All of a sudden, after a number of constitutional notices, they're now taking notice.
It's just pathetic. It's just so pathetic. And do you know, like, they responded to the chain in which the judge has asked twice whether they're okay with the submissions being extended to 7th of July.
Yes.
It still didn't fucking respond to that question.
Oh, sure. I thought they said they're okay with 7th of July.
They said that?
Yeah, I think so. Look, I'm pretty sure they said they had no issue with extending the 7th of July from memory. Pretty sure.
I haven't come across, that's news to me. It's not in that chain, at least.
I'll pull it up, it's a bit hard.
No, no, I mean, unless they didn't copy me in and just copied you in.
No, we're reading the same email. I'm pretty sure, I thought they said they had no issue with extending it to the 7th of July.
Okay, if they had said that, then she would have made an order. She's still not made an order. She would have made an order immediately if they had said that.
Yeah, but that email only went yesterday.
Ah, okay, it's part of the same email, sorry.
Yeah.
It's part of the same email, it's not. I was so fucking enraged by the first few paragraphs, I couldn't even read it until the end. I'm not even kidding. Because I've not started working on it yet, but...
Yeah.
Do you know, like, why are they mixing... This fucking asshole, like the judge, she's basically vilifying me for... I don't even know, I'm not breaking even a rule, but she thinks that I'm being a little bit too aggressive or whatever. And these fuckers, they're, putting information from one proceeding in the chain of another fucking proceeding. I mean, this chain has nothing to do with the 642 matter.
No, I get that.
And no, but this is really wrong because what they're doing is there's pseudonym orders in one matter, and then they're perverting the fucking chain here. It's so fucking wrong. I mean, it's practically entrapment because now if we publish the chain about this matter, they've corrupted it. No, not just that, but like as a matter of principle, everything in this proceeding is public record. And when the registry is copied in, people can actually inspect the emails as well. And they're, and that's why they want the two matters to be listed together, because they saw what happened at the Supreme Court hearing. They know that there's no way they can get a suppression order because the criteria is not met. Literally, the authorities that talk about the thing, they say that a lot of people will face tremendous trauma by attending court and blah blah blah, but it's a price that you have to pay for open justice, you know. And these fuckers, they want to loot and rape and steal, but you know, not be criticized for it because they. Not for their own purpose, but because it'll bring the administration of justice into disrepute. Anyway, so I was gonna write a very fucking that's why I was calling you. I wanted to write a very nasty email to the judge, and you know what struck me?
Well, you can write a nasty email about them. That's fine.
No, about her too, because what really. No. Let me just say this, Peter. You don't know what's happening, and there's every indication that something sinister. I mean, okay, I'm not trying to be conspiratorial, but that's not who I am. But what I'm saying is that, okay, so she had suggested that both matters be heard together. Remember?
Mm-hmm.
These people were too dumb to understand that she was trying to help them immediately. But they thought about it and they've come back with it. If both matters are heard together, it is so fucking bad for us. Do you understand that?
Well, but when they say they're heard together, they're saying they're heard together, but they've got to still be separate matters.
No, but okay, understand this. This proceeding will have if it's not a closed court, it will be very similar to a closed court.
Yes, I understand that.
Which is horrible for us because it means that reporters cannot be present. Or we cannot make...
Hang on, but they're two separate matters still. They're not...
No, but if they're heard together, then the fact is that the pseudonym orders and all of the other things will govern the procedure.
I would have thought though, if they've got two separate matters, they're two separate matters. They're not saying they're heard together. I don't think they're saying.
Yes, that's what they're saying.
On the same day.
No, that's what they're saying.
They're going to be two separate.
Okay.
No, well, I beg to differ.
Okay, I know that's what they're saying, and trust me, that's what they're saying. And I just attended the Supreme Court. That's what they did there. There were three matters listed together, and they were supposed to be called one after the other, but they don't really give a fuck about the formality, the judges and judicial registrars, and they basically started hearing, and I was, scolding them about it, but anyway, they.
To be honest with you, I think more of the fact she's nothing suspicious. I think she's thinking in her own mind, it's more convenient to have them heard together. I would think that would be the major reason, for rather than having two separate hearings to get them all, everyone on this, do it at the same time.
Okay,
that
so,
would be thinking, honest.
Yeah, and I don't disagree with you, but when you analyze a judge's behavior, you should always assume that this is the law, by the way. I'm not making this up. This is literally, I'm quoting an authority, which is the preeminent authority.
No, I'm not doubting what you're saying. But
So when you analyze a judge's behavior, you have to presume that she or he has thought about everything. And I know they don't actually. I understand. I know.
The first thought would have been, everyone's here together, we'll have them heard together. That would be the first thought.
I know, but what I'm saying is that
They're like that.
I accept that, but the reason why the principle is this, it's because judges have a lot of protection, and this is to give the other side some accountability. Because with all the fucking judicial immunity and all of that stuff, if you start giving them the benefit of doubt as well, then they can eat people alive. And that's the countervailing, that's the check on them, that you can criticize a judge for doing everything with deliberation and with intent. And also, it's impossible for us in our position to know anything for sure because you can't normally question a judge or interrogate them. So you have to assume that a judge does whatever they do deliberately. And my problem is that so they wrote this email after Lulu had written an email, and they didn't write in the same fucking chain. Do you see?
So they didn't write in the same chain.
Yes. So there's a separate chain that the judge had started for the other matter.
Yeah.
Lulu responded in that chain.
Yes.
With our response, and they are not responding. So they think that she's not reading that email, so they're not attracting attention to that email by responding to that chain. Do you see what I'm saying?
Yeah.
And in that email, we said we need at least 1.5 days because we need to cross-examine this fucking asshole, Heath. And anyway, so this is what I'm gonna do, all right?
Yep.
Firstly, I'm gonna say that the hearing must be in person. I mean, she can be in Brisbane, but all of us should attend the court physically because we're gonna cross-examine Heath in person, and not, through the fucking Teams. There's extensive authority. I mean, we've gone through this at the time of the.
No. I don't have an issue with that. That's fine.
And at least half a day's worth of cross-examination of him, because there's 3 people that would want to cross-examine. I mean, each of us, right? Even if we do it for 1.5 hours each, we should get at least 4.5 hours to cross-examine him. Because he's accusing all of us of the same thing. I mean, it's another thing that maybe I'll take your time, but still.
Yeah. No, that's okay.
That's the first thing. The second thing is that we will issue the subpoena in this proceeding. Okay? And then they're fucked because it's coming on very quickly, and we will have the material before the appeal is heard, which will devastate them. Do you understand the relevance?
What do you mean? What do you mean relevance?
So we will subpoena their communication with Gorton.
Yeah. I understand that.
But do you know?
More than relevance. I understand the importance.
Yeah, but what's the argument? Do you understand the argument why we're doing it?
Well, of course, to obtain the communications.
Yeah, but why is it necessary in this proceeding, in the injunction proceeding?
Why is it necessary in the injunction proceeding?
It's because.
It will demonstrate that it will demonstrate that the whole thing is been a collusion, and they've known about it for ages.
Yeah, but why is that relevant to them getting an injunction against us?
Well, it's got to be because any injunction proceedings. Well, first thing it's got to be of some urgency.
No. So this is the relevance. It's because what they're saying, this is their fundamental case. They're saying that we've had a long dispute with them. We've made a lot of allegations. Those allegations have been tested in court, and Gorton has found against us. And Gorton has made a number of orders against us, and we've lost in court, and we are bitter and vindictive and malicious and evil. And because we've lost in court, we now want to do everything we can to basically stymie their statutory operation as a means of taking revenge and as a means of stopping them from holding us to account after Gorton has found us to be wrong. That's their case, basically. That we have no credible allegations against them, which is why Gorton has ruled against us. And that's why the evidence is relevant, because, it shows that their whole narrative that we're evil and we're wrong at law is wrong, because Gorton is not a fucking judge.
Well, I actually sort of said that.
No.
Said that, of course, the evidence was going to show that exactly that what we've been saying.
Yeah. I mean, I'm not trying to be critical. I'm just saying, I'm telling you this so.
Okay.
Yeah, because okay, that's great. So long as we're on the same page, because they may ask you during the hearing, and
No.
So that's basically the point of the relevance, and it's like critically relevant. Do you see what I'm saying?
Yes, absolutely.
So we subpoena the fucking evidence there, and that's the first thing. The second thing is that I'm gonna. So what I had written to the judge was that we are in the process of filing a recusal application against her, and we don't want to. Like, it's best that we file it, like make the allegations that we're making on affidavit because of the seriousness of the allegations. I basically want to put it in her head that it's going to be fucking brutal what we put through the affidavit, because it is going to be brutal and she needs to have some indication of it. That's the first thing. The second thing is that besides everything that we previously discussed, I'm also going to attack her about the subpoena issue, like how she blocked me, and the fact that these people are basically shaming her, right? Because they're telling her about the law that she failed to enforce, despite me telling her the same thing during the hearing. It's just like what they did with J.R. Ellis, when I was asking for the matter to be referred. They wouldn't fucking tell her, and then later on, when I put them on notice that I will sue them personally, then they wrote to her and said that no jurisdiction anymore, just before the fucking hearing. And I will shame her, because I will say that the rules are there for a fucking reason, like there is a reason why the barrister should not lie or should not make submissions without thinking. And what she's doing is basically preventing the law to be applied, from being applied, because she thinks that it's unnecessary in their case. And I mean, besides everything else, she's so fucking insensitive to the fact that, okay, this is the thing, all right? This is the strongest argument in favor of it. In stopping us from making the complaint preemptively, she's making some presumptions about our intention. Okay, you don't get this. No, I'm not saying that to criticize you, but what I'm saying is that this is why it's relevant, okay? With J.R. Ellis, we asked during the hearing, I'm sorry I'm interrupting myself and it's breaking the flow, but there's a number of things that come up in my mind as I speak, and anyway, this is a solid argument. Try to listen to this carefully. So, on the first hearing, 3rd of April, with J.R. Ellis, they did not do the right thing.
She's wrong, I get that.
No, but let me explain this argument to you. This is a very novel argument. So 3rd of April, we asked her to refer to the matter to the judge. She was clearly not doing the right thing, and at one point she also indicated to the parties whether or not everybody consented. They did not say anything. And then on the other hand, they gave every indication that they wanted her to decide the matter. So they didn't address that question directly because it would implicate them, but they answered it indirectly by asking her to hurry up and decide the matter herself. Then immediately after, not immediately after, but well before the hearing, we again asked her to recuse herself. They didn't write to her, they didn't do anything. Then on the last day, we kept doing it as well. They didn't do anything, and then I wrote to them and I threatened them. and the barrister.
No problem you writing to her and,
No,
correcting her.
but here's the thing. It was because that happened at the last minute that the matter then had to go to a duty judge.
Mm-hmm.
Okay? And then what happened there is that there was such an obvious case for Bennett's recusal.
Mm.
It wasn't even controversial. In fact, they had made the fucking disclosure.
Mm.
And then they didn't take a position, but they fucking took a position throughout the day. In fact, the Lawyers Weekly article said that they took a position to oppose the thing. And they had brought the fucking reporter with them. Because even before the hearing started, the barrister said that his solicitors have informed him that there's going to be media present.
Yeah.
How would he know? Unless they have organized.
Cool.
So we.
Now, look, I'm sorry to interrupt. I'm here. The people are just about to walk out.
Okay. Yeah. So you can go when they come. Yeah.
Yeah. You're just coming out the door now. I'll ring you on the way back from the airport.
When? What time?
Well, it'll be 7:30, something like that.
Okay, that's fine. I'll speak to you then.
Okay.
Yeah.
Great.
Cheers. Bye.
Thanks. Bye.